Hello, this is Alex Lee, and today I'd like to talk about this big picture of the contract course, MB perspective. Okay, in the last video, I explained that there are 7 courses we need to study, and one of them is contract. And I believe once we memorize this 8 subject within this contract as a skeleton, I believe it would be easy for us to approach this contract course. So I'd like to quickly explain what this skeleton is about. Okay, first one is what law we apply. When I say what law we apply is, basically there are 2 laws we need to think about. One is common law. Second is UCC Article 2. When it comes to the sales of good, we need to apply Article 2 UCC or UCC Article number 2, whatever you can call. Okay, so the significance is when it comes to the sales of good, you cannot apply this common law. You should apply this Article number 2 UCC, right? So once you define what law we need to apply, you just move next. Next is whether the contract is enforceable. We need to think about whether this contract is enforceable or not. Depending on the conclusion, we need to just move, okay, let's just think about the performance or excuse. Okay, if there is no enforceable contract, we just think about kind of the nullification or void or avoidable, blah, blah, right? So we need to think about whether the contract is enforceable. In order to say the contract is enforceable, we need to think about these 3 categories, right? One is offer, second is acceptance, third is consideration. We need to figure out whether there is a valid offer, valid acceptance, valid consideration. I'm going to go over this briefly first, and then for each category, and I'm going to explain later. Okay? So once we think there are enforceable contracts, we need to move on whether there is a defense that bars the contract. You know what defense is? Once there is a contract, some parties, they would like to just challenge that this contract is not enforceable. So we can call it as a defense, right? There are 7 or 8 categories of defense. I can say here, lack of capacity, endurance, fraud, illegality, mutual mistake, unilateral mistake, and then unconscionability and statute of fraud. I can go over one by one, but this clip is kind of going over briefly. Before I move on, we need to think about the statute of fraud in depth, more detail. So I recommend you study the statute of fraud first before you just think about many other courses, because as far as I remember, this statute of fraud is kind of frequent kind of question you can encounter in the bar exam. So this is a small tip. Okay, next thing is, once you just think about these 3 steps, you need to think about, wow, there is a interpretation issue. How can we resolve this problem? Whether it's an MBE or ME course, you need to think about when you encounter kind of interpretation issue in contract, you need to think about whether there is a parallel evidence rule issue, or there is an ambiguity issue, or there is a modification issue. In each subject, you need to memorize all the elements, and you need to think about analysis. So let's talk about this logic later. Once you thought about this whole thing, you need to move on whether there is excuse for the non-performance. Okay? Let's think about this. If there is a contract, there should be a performance. If there is no performance, you have to think about excuse for the non-performance, right? So when I just see this kind of categories here, I can read to you: express condition precedent, implied condition, impossibility, frustration of purpose, impracticability, and subsequent agreement by the parties. Okay, when I see this one by one, I can imagine what they're gonna talk about. But before you get into this specific category, so think about, we are talking about this excuse for the non-performance. We have a 7 or 8 kind of excuse we need to memorize, right? Once you obtain this excuse in your mind, let's just move on to the anticipatory repudiation. And then I recommend you go directly to the third-party beneficiary, assignment, and delegation. When you think about this bar exam frequency perspective, you need to focus more on kind of the contract enforceability, excuse for the non-performance, and what law applies. This kind of thing has more significance than repudiation or anticipatory repudiation issue kind of thing, right? So let me just talk about this frequency later, but this is just a small tip as a second tip. And once you just finish the whole thing, just think about remedy. This remedy is one of the important subjects in contract. So I'd like to just introduce what remedy we need to think about. One is expectation, reliance, restitution, consequential, incidental. And then this is kind of one category I recommend you memorize first. And then I recommend to think about liquidated damage and specific performance. When you just try to resolve whole problem, you can easily see the liquidated damage and specific performance and other kind of the big damages categories. Okay, so this is the whole thing, I think, as a big picture of the contract. So once you memorize this 7, 8, 8 big categories, let's just move on specific category each. Okay, see you, bye-bye.